Hello everyone. Welcome to R&A Knowledge Series 2026. My name is Sandeep and I will be moderating today's session. So as many of you are aware that R&A is celebrating 30 years. So uh, being a part of this milestone, we have planned series of webinars on various topics. So today's session is fourth webinar and the topic is beneficial ownership under section 89 and 90 of the Companies Act. So our team has gone through the sections and rules and identified a few questions which we have already shared it in the group so that this will be the discussion part with the experts today. So before moving forward, I would like to introduce the experts today. Today's experts are CS Venkata Ramana sir, CS Ramakrishna Gupta sir. Welcome sir.
Thank you. Sandeep.
So yeah. So before moving forward, sir, the very basic questions I would like to ask about section 89 and 90. What is the basic difference between?
Sandeep,
Yeah, yeah.
let me say two words first.
Yeah, please.
Thank you. Very good afternoon, everybody. And at the outset, I would like to first congratulate the R&A Associates, being I was also part of the R&A Associates in the year 2000 to 2001 till November 2001. And I was very blessed to have training under Rashida Madam and Ragbabu sir that time. And now I'm into the ICSA, as you know, I'm now Central Council member and also have been into the profession with the platform and the base given by the R&A with the blessings of the madam and Raghu sir. Now we could reach to that stage and now, thank you very much once again, Sandeep, for wonderfully coordinating for these sessions. It's really the order of the day where we will learn the subject, we will share the knowledge with all others, and we will also learn a lot many things while on the discussion. So, we're looking forward for everybody to have a fruitful discussion on the entire subject, and you will be free to ask any kind of questions or interrupt in between. There is no problem with that. Yeah.
So that's the reason, sir. You are the expert in this 18 and 90. So yeah, interruption will be there. So just wanted to ask this question, sir. This section 90 was not earlier. It was not there earlier. SBO
Yes.
concept, and it was introduced in 2019. And 89 was there even in the earlier act also, section 187C. What is the reason for bringing this section 90, and what is the difference between these both sections?
Actually, Section 89 was a very simple section, 1956 Act. If you go through the earlier provisions 187, where the company's shares are held in its name and where the two shareholder concept, minimum shareholders concept was there, the shareholding used to be held for the purpose of to adding two shareholders in the company and whoever is not having the beneficial ownership, not a registered owner, has to give the declaration. That was the original provision. If it was there in 1956 as well. Now this section 90 is a different concept altogether. After the introduction of SBO, especially keeping in view that a lot of foreign investment coming from a lot of foreign resources and people have been using like Mauritius and all. There were so many tax haven countries were there. So end of the day, the government could not understand who is the real persons behind the investments and who is the real owner of the company. If some and there were some anti-social these things like money laundering issues, PMLA, these things. So there are many factors which is to avoid anti-terrorist these things activities. If you all remember, then earlier there was Hamala transactions used to happen. A very lot of Hawala transactions using this platform, corporate platform. So to find this, the section 90 was introduced by government, and now the ministry, the government wants to know who is the real persons behind the entity, especially where the multiple layers of investments are there. If you see, there is a change also in the layers.
Varshita, you have to mute.
Yeah.
Yeah.
Yeah. Even under the 2 layers investments have been restricted now. Not more than that. Cross holdings have been restricted now. So this is the purpose of SBO. So we need to understand who is the significant. One important thing we need to understand is under SBO, we need to find the ultimate significant beneficial owner or ultimate beneficial owner of the any Indian company. So it is applicable only to Indian entities as a reporting company, and the responsibility is now on the company secretary, who is compliance officer of the Indian company, to find the ultimate beneficial owner of its own investments.
Okay. So what I understand is Section 89 is like generally most of the 80% of the situation is where there is a wholly owned subsidiary, and for the purpose of the statutory requirement, you need two shareholders. For that, as a nominee, Section 89 will be applied, whereas under Section 90, an individual need to be discovered who is the person behind behind a corporate entity indirectly holding.
Yes, that is only one of the point. If you
Right.
see what is the difference is, here in 89, even a trust may be the beneficial owner. Even a company may be the beneficial owner. Even
Right.
any kind of entity is a beneficial owner. But in the SBO concept, it is only an individual where
Individual.
we need to find finally who is the beneficial owner. So in the 4 and 5 is reporting mechanism is applicable. Whoever is the registered owner has to give declaration who is on behalf of whom this beneficial ownership he is holding the shares, and beneficial owner also should say this fellow is holding on my behalf.
So, yeah, if we move on to the question number two, the question is if the beneficial owner has already made a declaration under Section 89, so he has filed MGT 4 and 5, and do the same person is required to file Ben 1 as well if he falls under 90?
If he falls under 90, you have
Oh.
rightly put up that rider point. If a same person is holding a beneficial ownership under 89, as well as on the other hand, he is also falling under 90. That means the basic criteria of both of this is direct beneficial ownership, indirect beneficial ownership. Direct beneficial ownership means only two persons are there. X is holding on behalf of Y.
Right.
That is direct beneficial owner. Now, instead of X is holding on behalf of Y, some ABC company or some non-individual entity is holding the shares on behalf of Y, and it is in the X company. So there is a third person is coming in between. In that situation, this SBO concept would arise. And in case the same individual, like I am holding 1 lakh shares and a beneficial ownership, 10,000 shares directly Y is holding, X is holding on behalf of me. Apart from that, I have also having one more entity, company, XYZ Private Limited. That XYZ Private Limited is also having shares in the same company where I have this 10,000 shares.
Right.
Then both will come into picture.
So, do I need to comply both the provisions?
You need to comply. You need to comply.
I think there is a provision, sir, under the Section 90, the rules. It says that if you have if you have filed MGT 456 and you have complied with the provision of 89, then that is treated as directed
Yeah, I
direct
will tell
holding
you. I
on.
will tell you in the same example. If you take, like A Limited is a company.
Right.
In A Limited, Y is a beneficial owner. X is holding shares in the A Limited on behalf of Y. Some 10,000 shares. Okay. For this, he has given 4 and 5.
Right.
And now, in the same A Limited, Y is holding through a partnership firm.
Okay.
And also a private limited company. In turn, this also hold more than 10% shares.
Okay.
Both private limited company also hold more than 10% shares. A partnership firm also hold more than 10% shares. Then, what he has to do, only for this 10% shares through indirect beneficial ownership, he will report. So what exactly you said is absolutely right. When he filed Ben 1 form, he will exclude this 10,000 direct holding beneficial ownership shares number from that list. Balance he has to report as a SBO. So for this another 10%, that 10% you may take like 3 lakhs shares.
Okay.
So this 3 lakhs on behalf of XYZ Private Limited, he is holding in A Limited, that he has to report, or XYZ partnership firm he is holding also, then also he will report. So both sub will come in one this thing. Understood? Some question has come from
Some
Arjun.
question has come. He says that Mr. X was holding shares on behalf of ABC Limited.
On behalf of ABC Limited.
Indirectly holding through ABC Limited, maybe as a beneficial owner, and compliance of Section 89 was made. So MGT 45 has been filed.
Yes.
Now Mr. Y has acquired shares from X, where the shares are held on behalf of ABC Limited.
Just let me open that person, because or he can over the phone, over the call, he can ask.
Okay.
In chat box it is there.
Arjun, you can directly ask the question.
Sir, you
are saying something.
You can see in the chat box.
In chat box that question was posted there. Maybe Arjun has posted. So we can follow.
If Arjun is on the call, he can unmute and
he can directly unmute and ask the question. That is better actually.
Hi, sir. This side Arjun. So my question is with respect to sir that Mr. X was there who was holding the beneficial ownership of the shares on behalf of nominee, as a nominee shareholder. MGT 456 was filed. Okay.
Nominee shareholder. No, 1 minute. Let us go slowly. Nominee shareholder of whom?
Nominee shareholder of Mr. ABC Limited.
Okay.
Okay, as well as he is a beneficial owner also under Section 90, because he is holding the ultimate holding company majority
indirectly.
Okay.
Okay. So as a nominee, he is holding the shares, and as well as a SBO is holding the shares in the company. Okay, compliance of 89 and 90 both were made.
Yes.
Now the husband has transferred the shares to the wife. Okay, so the nominee, whoever was holding shares as a nominee as Mr. X, is no more existing as on today. So if you see Section 89, it says any change in the beneficial ownership as a nominee, you should report.
Yes.
By filing the revised MGT 456. So whether since I am not existing as on date, totally my name is deleted from the nominee shareholder. Okay. So whether 89(2) compliance is required or not is my question.
You mean to say there is a change in direct beneficial ownership, not indirect beneficial ownership? Yes?
Yes. Indirect beneficial 90 is continuing. 90 is continuing. There is no change. 89 there is a change.
89 is continuing. So you will report as a 89 whatever requirement MGT 4 and 5.
No, 10, because I was holding 10 shares. I was holding 10 shares on behalf of the nominee as a nominee on behalf of ABC Limited. Now out of 10, there is no change because I have transferred entire shareholding of 10. So
you're saying that the nominee. Arjun, you're saying that the nominee has changed, right?
Yes, nominee has changed, right?
Sir, nominee change ayindi. Nominee change ayindante you'll file again MGT 456.
Same MGT 4 and 5.
MGT 456.
For a new nominee, I will file, no sir. For old nominee, whether it is required.
No, when you replace the nominee, new nominee, it automatically replaces the old also. There is no requirement again to change for old and all. One document itself will be like earlier it was held by X, now it will be Y.
No,
okay.
In the declaration itself, there is Arjun. There is in the declaration itself. It clearly mentions the reason for the transfer. You need to mention the reason and the change they are asking it. You need to mention the reason for or change the reason for the change. You need to mention there. That's enough. From the existing nominee shareholder to another nominee shareholder.
So the conclusion point is that whoever Mr. X was originally holding a nominee, okay, if his name get deleted, and new person comes, so whatever declaration which is made by new person will supersede the old declaration. That's all.
100%. You're right.
Arjun, you are right, but
I
it
have
is
done the
not.
same thing, so I just want to confirm from you also.
Arjun, what you said is right, but it is not deleted, it is replaced. Okay?
Word we can use replace instead of delete. No
Replace,
problem.
not deleted, replace.
Done, sir. I have done the same thing for one of my clients, so I
Correct,
just want to
correct.
confirm to you expert people also. So just have to be right. Thank you for your time.
Yeah. Sandeep,
Okay,
go ahead.
okay,
now.
sir. The answer for the second question is you need to comply both the provisions.
Both the provisions to the
Yes.
extent of
Indirect shareholding for 90.
indirect holding separately, direct holding separately. Don't club and mix up it. Okay.
Sir, in
Sure,
case
sure.
of a trust,
Hmm.
trust you will file MGT 456 as well. And
Hmm.
at the same time, section 90 maybe there is a provision with respect to trust that if there are different kind of trust, then settler or the trustee has to file it. So in that case, if the trust has filed already MGT 456, will it apply for?
See, one thing you have to understand. Once it is a trust mode, and direct beneficiaries of the trust will become trust beneficiaries of the shares.
Right.
Directly. Okay. So there is no question of indirect holding there. Indirect beneficial ownership is not there. It is a direct beneficial ownership which is signed from the trust to them.
Right.
So once they file there, in the explanation to that rules itself they have given that wherever the MG 89 compliance is made for the direct holding, then it will be exclusion of section 90. So it will not come again.
Right.
But in the same trust is also in the same trust is also having like another trust in it under it, because two trusts can form another trust also.
Okay.
It will be a little bit more complicated because I have seen these kind of things with all due respect to the big four audit firms. They will structure the family business or family this thing in such a way that trust will be again owned by two Section 8 companies. And those two Section 8 companies may again some LLPs or something will be the shareholders. Like that, they will make more complicated things. So only to the extent of the shares held in direct beneficial ownership, to that extent, 89 is sufficient. 90 will not come into picture. But wherever 90 attraction happens,
Indirect shareholding and individual is there.
Individual is behind it, then it will come.
Right.
Because what will happen in the same trust, Karta will independently own some of the shares, more than 10% indirectly through some other trust.
Right.
He cannot say that this trust I am Karta, already I am reporting there in the 89, so I will not be, I should be excluded from 90. He cannot say. Understood?
Right. Understood.
I think if anybody has cross questions, they can ask, because what I am explaining maybe properly received or not by them.
No, sir, it's very clear.
I think we need to elaborate this explanation with respect to investment held by trust. See, in case of investment held by trust, generally the shares will be in the name of the Karta.
Trustee.
Right?
Ramki, your voice is little low. You should
okay.
speak
What I'm saying, in case the trustee is a investor in the company, so shares are held in whose name?
Trustee, sir.
Trustee or Kartas?
Karta, HUF it will be.
Trustee name, HUF. No, that is HUF. Okay, trustee name. So, but if the trust has multiple beneficiaries, the trust has multiple beneficiaries, so and shares are held in the name of the trustee. Trustee will file a declaration saying that these are the beneficiaries.
Yeah, I will tell Ramki what is the difference is. The rational or the test check is here whether it is a direct beneficial ownership or indirect beneficial ownership. When a trust is a shareholder, and trustee's name is entered in the register of members of the company, all the beneficial owners of the trust are direct beneficial owners of the shares held by the trust.
But you don't know what are the beneficiaries. How the public will know what
No,
are
no,
the
you need not require to know. Why? Because the trust itself, the ministry is not intended to find once a MGT 4 is filed, 5 is filed as a direct beneficial owner, the purpose is achieved for the compliance of the provision and the ministry is happy. Only when indirect beneficial ownership you are accruing. That's why if you see in the direct beneficial ownership, even 1 share you held or 1% you held or 10% you held, irrespective of number of shares, irrespective of percentage of shares, the reporting will happen and it is over there. But in the SBO concept, the 10% minimum holding is required, that to indirect holding.
Right.
What I'm saying to elaborate this question further. If the trustee, this trust investment is more than 10%.
Okay, in the company.
Shares are held in the name of trustee. But trustee is not the beneficiary here.
I think we need to elaborate this here. There are 3 types of trusts in the rules where it's been provided in the rules. It says that there is a specific trust. In case of a specific trust, then beneficiary is a SBO. In case of a discretionary trust, then trustee. And in case of a revocable trust, then author or settler.
No, I will tell the reason also, Sandeep. Wait.
I don't see these things will vary. Will change the nature of the trust.
Nature of the correct. What is
and all okay? Discretionary trust is only at the instance of the beneficiaries. It will continue. That will not change. What I'm saying, in all the category, beneficiaries is different. Beneficiaries, we have to see who are the beneficiaries. So if the say in all the cases, trustee need not be the only beneficiary of the trust. Obviously, beneficiaries will be different from the trustee. Maybe at the mostly even trustee also one of the beneficiary.
Ramki.
Wait. If the entire investment of more than 10% above are held in the name of trustee, and you file the declarations under 89 MGT like MGT 4, 5, and then intern company 6. Don't you think we need to disclose the under 892? Because
no. Why? Because you can yesterday
my trust deed has very categorically
understood, Ramki.
Very category defines who are the beneficiaries and their share. Otherwise scenario, trust is holding more than 30%, and there are only 3 beneficiaries. Each of them equally holding 10%. So then each of them becomes beneficiaries of the 10%, and so will it not be an indirect holding? I will holding through a trust in a company. So is it not that you need to disclose who are those beneficiaries under Section 90?
I will tell you, because of this kind of issues will come, there is an explanation provided in the definition itself. Can you place that yesterday what we were, this thing, I think you have that explanation with you. I also have, I will open my presentation once.
What do you want me to share, sir?
That rules ka declaration 1, that explanation 1. In the rules it is there, no explanation.
Yeah, it is there, sir. I opened it.
You just open that. In the explanation, I will read out that explanation for all the benefit of everybody. I think rule 2 and I think I or H.
I hear it, sir.
1 minute. Rule 2.
Rule 2.
Explanation.
Definitions.
1 minute. Ramgi, wait, please wait. Very small, yeah.
H defines who is
Go above. Yeah, here. Sub-rule 2, you can see. Above that. The individual or acquirer is a beneficial owner in the shares of the reporting company under subsection 2 of section 89 and has made declaration to the reporting company. This shall be direct holding and should not be treated as indirect holding. So he has given in the form of explanation that it cannot be treated as indirect holding. It is always be treated as direct beneficial holding. So it will not, once you declare there, it will not come here.
That is true, but I'm saying in the scenario which I explained, which we have just discussed, benefit shares are held in the name of trustee, and investment is more, let us say, around 30%.
Doesn't matter, Ramki. Ramki, it doesn't matter. 30%, 20%, it doesn't matter.
No, why I'm saying 30%? Because 30% beneficiary, ultimate beneficial owners are 3 beneficiaries. And each of them are, as per the trust deed, each of them has the 10% interest in those shares. Okay.
10% in our even 30%, 33%, 33%, you can say. Out of that 30%, 33% each one is holding. Like that you say.
What I'm saying, okay.
For better example.
No. Since you were saying that 10% is the criteria there under section 90, all the 3 beneficiaries holds 10% indirectly.
Okay. Here I will explain you one thing. Please do not confuse anybody who is dealing with SBO. What is the cake or share of either X or Y or Z in the holding of 10%? That is not the criteria to understand. And in the reporting mechanism also, we need not check that. The problem earlier was people was to try, like if a partnership firm is having an SBO, is every partner is SBO, one partner is having 10% share in the partnership firm, one person is having 50% share in the partnership firm, how I will report and all. It all, the ministry or the purpose of this section is not to find out how much cake you will get out of that indirect beneficial holding. No. What is required is whether you are a beneficial owner or not. That is to be reported, that is to be identified. The only purpose of this section is to identify, not to understand how much cake you will earn or get out of that portion of beneficial ownership.
Whether the threshold limit is exceeding or not.
No, that's all. Only if, see, if I will put in a nutshell, simple nutshell, if you have to check, you take the reporting company, take the list of shareholders, exclude all individual shareholders directly, remove them. You find out non-individual shareholders, one company, one LLP, one partnership firm. Identify whether this entity is non-individual shareholder is holding more than 10% in that entity. Yes. Then try to find out who is behind that fellow. If it is a company, private limited company or body corporate, then 3 criteria has to be followed. Criteria 1, who is holding more than 50% of shares in that company. Category 2, whether he is having entitlement for dividend or voting rights more than 50% in that company. Third category, whether he is having control over that entity or significant influence over that entity. If these 4 criteria are found, then in that private limited company, he will become a any of these criteria he met, then he will be deemed to be having control over that entity. This control is having these 3 parts. So once he has a control, he will become SBO automatically. That is private company position. If it is a partnership firm, normal partnership firm or LLP, you need not do anything. Every partner of that LLP, every partner of that partnership firm will automatically become SBO. Irrespective of their cake, they share in this partnership firm. If it is a trust, then again what you will do, you will check 3 points. Whether it is a specific trust or discretionary trust or
revocable
trust. What is specific trust? We need to understand. Specific trust means in the trust, the beneficial owner cake percentage is categorically maintained, how much share he will get out of this trust property. That is specific trust. That is the nature of specific trust. When it is a nature of discretionary trust, the trustee will have the discretionary power to give what cake to who beneficiary. Like if I am love X more, I will give 50% to him, and YZ I will give only balance 25%. That is discretionary trust. So in the discretionary trust, trustee will have the authority and power to how much cake they have to distribute. So that's why that case is separately defined. The next case is revocable trust. In revocable trust, author himself will become SBO. Why? Because we don't know. Anytime he will revoke the trust and he will say, I am holder of this property. So this is why the trust is defined like that. Now if it comes to HUF, what it will happen? In the HUF, the Karta is the person who will control over the property. So always Karta will be treated as a SBO.
SBO.
So this is the whole understanding. And last, pooled investment vehicle. When pooled investment vehicle is there, then the criteria is two types. Whether that pooled investment vehicle is originated from the country where FATF arrangement is there, or agreement is signed by India, or it is not falling under that country. So based on that, we will identify who is that SBO. That will come in the latter. I have that this thing also. I will explain later. Now you can go ahead, Sandeep. Briefly, this is the provision.
I think you have covered everything in this particular segment with respect to all the entities. So we'll move on to the third question. The third question. Section 90 focuses on identifying natural person behind the corporate structure. Where the ultimate shareholder is a government-owned foreign corporation, how should the reporting company identify the SBO? So this question, I'm because Section 89 is not applicable to government companies, and by virtue of that, even Section 90, most of the we don't comply with the provision. If it is a government company, then the Section 90 also not applicable. Means we don't follow the SBO rules for government company. So in case of a foreign company, it is not specifically mentioned anywhere in both the sections. What do you say? Means, do the government company need to comply with the SBO requirements?
First of all, Sandeep, good that you have made a very tricky question, drafted the question very typically, but I want to explain that 89 also section has not given any exemption to private government company, but the notification issued in 2015, somewhere March or May, there
June.
the government June that government companies exemption was came for section 89 because every share is held by the President of India and he is our governor of the state. So there is no requirement for filing 89 and all because all the holding is government. Now, fortunately, unfortunately, in the rules, the same exemption was not categorically provided either in the rules or section or in the explanation to the rules. But however, as far as my understanding, the government, Indian government companies is not required to go for section 90 or SBO because anyway government is holding it. Government knows who is the beneficial owner. It is only the public is the beneficial owner. So no need to require to identify. Point one. Then it comes to the foreign government entity, owned corporation. What will happen in the foreign government owned corporation? First of all, we need to understand whether in that foreign country, whether the corporation is defined government owned corporation. Like in Indian Companies Act, we defined the government company
Definition is there. Yeah.
But there it is there or not, it is not. First question is that. Second question is, there are even some countries still which is not a non-democratic methodology. Maybe kingdom is there, maybe something else is there, or democratic process is there, constitution is there or not there. So which kind of country-owned corporation is that? If you find that in that corporation also somebody else is a beneficial owner, though it is called as a government entity there, then you need to do that exercise. Otherwise, take a declaration from Benwan that nobody is having beneficial ownership except the government or public, then you are safe.
Okay. So an extended question to this, sir. See, the foreign national, there is a penal provision for the foreign national also if they don't make a declaration for PAN.
Correct.
How an Indian government means like RD or NCLT RD or ROC can give a penal provision to the individuals.
No, it is not an individual. Foreign national
Foreign
Indian is not going to do because a lot of international treaty agreements and all come. It is all the penalty of the 90 is on the company and company's directors and the officers in default of the Indian company, not for the foreign shareholder. Okay. So if you open that this thing, I will read out. In the rules cannot give.
See, sir, 90 subsection 10 says if a person fails to make a declaration as required under subsection 1, he shall be liable for penalty of 50,000 rupees and in case of continuing failure with a further penalty of 1,000 rupees. So this is for the individual only, right?
This is for individual only. Yes. So you are telling foreign holder is SBO is not giving the declaration.
Right. How come ROC or RD can make a penal provision on the foreign national? Generally, have you come across through any?
No, it is subject to legal proceedings only. I think no case has been made so far in this thing by the MCA because it is all subject to international laws. So very difficult to find this. Even actually, this is not a implementable provision unless he is an Indian.
Yes. So you cannot make a track of it. That's what I was like. I wanted to understand.
You may make the track of it. If that fellow is Indian, you can fix him.
Right.
But if it's a foreign national, it is subject to again that international legal provisions and jurisdictional things.
Okay. So Satish Gupta, sir, I think he had a question on this. This question 3 with respect to foreign holding. Sir, you want to come in?
Yes.
Yeah.
Yeah. Hi, Ramna.
Hi, boss.
Yeah. Just to put it in different clarity, if in the same question, when I read the question 3 and just I pose a question to Sandeep, in case in addition to these foreign governments, if any other body corporate is holding more than 10%, and then in that body corporate 100% held by an individual. Body corporate is held 10% in that company, and in that body corporate, individual shareholder is holding 100%. So in that case, that individual shareholder who is holding 100% in that body corporate, in turn that body corporate holds only 10% in this company, whether that individual person will be deemed to be a SBO.
Yes, 100% is an SBO. See, in SBO concept, please do not understand that how this fellow will control the reporting company. It is not the purpose of this section 90. The ministry or the government of India doesn't require to understand who is having control over the reporting company. It is not the point. Who is having control over that more than 10% is that thing that government wants to identify. So if this 10% is held indirect beneficial holding by X or Y, if he is having 100% control or more than 50% control over that 10% of the investment, then he is an SBO.
But if you see in explanation 3, explanation 3, clause 3, subclause C.
Can you place it?
I will share.
Sandeep, please.
Explanation 3.
Sir, explanation 3?
Explanation 3 and 3, subclause 3.
Can you enlarge it? Sandeep, I will also open the book better.
Yeah, if you see 3, Come down little.
Ah.
3. Yeah.
This one.
Where the member of the reporting company, sorry, not the 3. Sorry, 1 only, sorry, 1. Where the member of the reporting company is a body corporate other than the LLP, and the individual who holds the majority stake in that member or holds majority stake in the ultimate holding company. So the what I said is the body corporate is holding only 10%. It is not a holding company, ultimate holding company. So how come a person holds 100% in that body corporate, which that body corporate is holding only 10%? How can you treat him as a SBO?
I will tell you. See, examples, can we place it there, Sandeep?
Yes, sir. You have an option to share. I'll stop the.
Okay. Because this question he has to understand. See, this ultimate holding company concept is come because of the where the foreign investments is pulled, sold from different layers of the companies. 1 minute.
So
I will try to.
If a body corporate holds only 10%, it will not be called as a ultimate holding company.
No, that's what I will tell you. Ultimate holding company picture will come only when that body corporate is having a holding company. In once, if you take an example, ABC Limited is an Indian company, R is a reporting company, Indian reporting company, R Limited is an Indian reporting company. In that R Indian reporting company, B is a body corporate who is holding 10% of the shares. In that company, body corporate, once X is holding 100% of the shares, there is no possibility for anybody to have control over that body corporate. Yes or no?
Yes.
100% control.
100% shareholding if he is having, X is having in that B body corporate investment company, which is a invested company. Nobody else will control that company. So ultimate holding company story will not come here. Ultimate story holding company story will come where there may be two situations. In that body corporate, another body corporate is holding more than 50%. In that body corporate, next level, another body corporate is holding more than 50% of the shares. It may be going in layers. Then why this ultimate holding company word was used in the explanation and section? Once you declare in the ultimate holding company who is a beneficial owner, all these underlying companies like we told B is a body corporate who is holding the shares. Then in the B, M is a company who is a holding company of B. Then for M, there is a N is a holding company of the B company, that is second layer company. Then once you declare who is SBO in N, who is controlling the N, and that fellow will become a SBO of reporting company. That ultimate holding company is found now, that SBO also fellow is found now for the reporting company. Then in between this Y company and M company need not report again when one. That was the concept introduced there. But in your question, once you told that B is a in first level of investment company having 10% in reporting company, and somebody A, B are holding 100% shares, then you will not go to the next layer, next level at all. You have to completely ignore that next connectivity. But one situation may come, though for namesake 100% holding is held by this fellow, but somebody is having significant influence or control indirectly on all the policy decisions or financial decisions of B Limited, then that fellow also will become SBO. This fellow 100% holder also become SBO, and the fellow who is having significant influence, that fellow also will become. Because as we see, in some companies, only an employee will be made 100% shareholder because they don't want to have. But end of the day, the financial decisions, all the policy decisions will be controlled indirectly with just by eyesight by somebody else. Your question is answered, Sandeep?
No, still I
You
differ.
can continue. You can continue.
No,
No problem.
so I little differ this your version because the explanation is given for the purpose of the proper understanding of the provision.
Correct.
So he clearly says
Hmm.
the SBO will be the person who holds majority stake in this holding company he's talking about. But 10% holding by a company will not be a holding company. Ramakrishna, if you can see.
Can I come in? Can I come in?
Yeah, that's what that's the reason I'm calling you.
Okay. So
Yeah.
what is the here? The presumption is that, as you say, Indian company is a reporting company, in which the body corporate is holding more than 10%. And he is saying, he is referring to an individual and also is referring to ultimate holding company.
Yes.
So the presumption is definitely could be this body corporate is a subsidiary of some holding company.
Correct.
Let us say, so body corporate, let us say company in Dubai, which is a subsidiary of another company in France. And that France company is a subsidiary of another company in US. So in that US company, the so-called individual is holding more than 50%. In such case, that individual is treated as a SBO for the reporting company in India. So I think we have to presume that there is structure beyond that body corporate. There is a structure there, more than one layer or two layers or three layers there in foreign destination. And the ultimate holding company, this individual is a shareholder holding more than 50%. So by virtue of he holding more than 50% in the ultimate holding company, which in turn has subsidiaries more than one or two or three layers, and the last layer of that subsidiary company which has invested in Indian company more than 10%. So if that was the relation exists, in that case, that individual becomes a SBO for Indian reporting company. That is, you understood?
Yeah, Sandeep, can you put that picture?
I am trying to put it.
No.
No,
Sandeep
yes,
is having
continue.
that one.
Regulation.
I'll stop this. Okay. See, Satish, only one thing, please understand. You need not get confused about.
I'm not confused, but
No,
just only
let me
clarity.
explain, Satish. No, అర్థమైంది. For that only I'm telling. What I'm telling is, your non-individual shareholder is a body corporate.
Holding only 10%.
10%. If 10% is there, then only you will be checked. Otherwise, you will
Correct.
not be counted at all.
Correct.
You will be completely ignored. Okay. So you are.
You see, one second. I'll tell you here this question.
Good.
You see, Mr. X and Mr. Y, both Mr. are there, but I am saying that instead of Mr. X, ABC is holding 11%. In this ABC, only the 100% share held by Mr. X. It's a separate scenario I'm talking about.
Different scenario.
I will tell you in this case.
Instead of Mr. X, ABC is holding 11%.
ABC is holding 11% in where? Satish,
in A Limited. ABC is holding in 11% in A Limited.
Then ABC is not a holding company.
That's what I'm saying.
ABC is not a holding company.
No, Satish, I will.
No. One second, Ramana. One second.
Let him finish, Ramana.
Yeah, ABC is holding 11% in A Limited.
Where is ABC? ABC is not seen here.
That's what Mr. X. Instead of Mr. X.
X Limited as ABC Limited.
Mr. X, no, Mr. X.
Mr. X is ABC Limited.
Mr. X is, you assume that Mr. X is ABC Limited.
Okay.
And in ABC Limited, X is holding 100%.
Okay.
The ABC Limited, which is having 11%, is not treated as a holding company, in my view.
Yes, definitely not.
Definitely not.
Definitely not. Then the person who is holding 100% in ABC Limited will not be treated as SBO.
True.
Arey,
Because there is no relation.
Satish, please try to understand. In SBO concept, holding or subsidiary company, the story will come not for the immediate investor, non-individual shareholder. Please understand. First, that's why I told in the first instance, your duty is take the list of your shareholders as a reporting company. Identify non-individual shareholders. It may be partnership firm, it may be company, it may be a trust. If it is a private limited company. Then you check this company may who is having the control or who is a shareholder having more than 50%. If nobody is having more than 50% in that company, it is neither a holding company. There is no holding company for that company. So the SBO will not arise in the ultimate holding story will not come there. Next, if some X fellow is there individual who is holding 50% above, unmute it.
In the holding company, 50% above?
Not in the holding company. Please, Satish.
Directly.
Just follow the line sequence I am telling with the concentration. You are a reporting company. In your reporting company, ABC Private Limited is having 10%. Now your story is only belongs to that ABC company, XYZ Private Limited. In that XYZ Private Limited, who are the shareholders? Having either more than 50% of shareholding or having more than 50% of the voting rights or dividend rights, or who is holding having a significant influence over that company, you check it. If that company there you are not finding anything, you find some other company is again holding more than 50%, then you reach to that company. That company is also you are not finding anybody. Again, there is another holding company for that company. Then you go to that company.
Of course.
There you find that layer you have to follow. Here, holding subsidiary is not in relation to the reporting company. Holding and subsidiary, ultimate holding company is for investee company in the reporting company.
No,
Okay. So whoever is the investee company in the reporting company, whether that company is having another holding company or only individuals holds the control or control through these three modes, then you will find the SBO. Now you ask any more clarification you want.
I think, Satish, you have to see ultimately.
So first he got cleared or not, you check. Otherwise, again it will go to more complication. Satish.
We will pass on.
You will pass on. Okay, no problem. Sandeep, you go ahead with this.
Yeah.
Otherwise, it will be a very lengthy subject.
Right.
The purpose is that whether you understood.
No, I understood. What I'm saying, the explanation is clearly mentioned. In the reporting company, if any individual holds majority stake in the ultimate holding company, it's saying that when the shareholder is a body corporate, and how you'll be finding this SBO, an individual who is holding majority stake in the holding company.
I'll make it simple. Let us see whether I can try. Say there is Indian reporting company.
Yes.
Its shareholder is a body corporate.
Yes.
And he's talking about ultimate holding company.
Yes.
So between body corporate, who is a shareholder of Indian company, and ultimate holding company, they assume that there are other 3-4 companies.
Yes.
So the relationship between this ultimate company, body corporate, and in between 3-4 companies should be necessarily in the form of holding and subsidiary only.
Correct.
Ramana, please correct me if I'm wrong.
Yes.
Correct me if I'm wrong. So unless the holding and subsidiary relationship exists between all these 3 or 4 companies, then only you will travel beyond upside companies and identify which is an ultimate holding company.
Holding company, correct.
If in that ultimate holding company is individual holding more than 50%, then he becomes the SBO of Indian company.
Yes.
In your
Okay.
example, X Limited, as it is X Limited is X
Ah.
Limited, you have to go up to X Limited.
X Limited is holding
You have to go up to
10%.
X Limited. If X Limited if somebody is holding more than 50%, then that person becomes SBO.
But X Limited does not hold, does not a holding company to this
No.
reporting company.
Reporting
But
company.
10% is
Satish, I will explain here. See, Satish, 1 minute. I will explain here. When you are discussing about the reporting company, don't think of in the reporting company whether there is a holding company exist or not. You forget first that. No need to think of that. Okay, just find out who is the
10%
shareholders holding more than 10%.
10%, yes.
If that seems to be like in the same example you are telling, B Limited is a like I Limited, we will say investee company. No, I Limited, we will say reporting company. R Limited, we will say R Limited is their reporting company. I Limited is their investment company, investee company. This investee company having 3 shareholders. One shareholder is 49% shares held by another P Limited. Then another 30% shares are held by one LLP or another LLP. Another is held by, balance is held by an individual. Situation 1. In this situation, neither this individual holds control, nor this body corporate, P Limited controls. So there is no holding company. There is no SBO here. Only SBO may be if it is a partnership firm, that partnership firm, all partners will become SBOs. Next level question, same extension of this. In the same investee I Limited, 51% shares are held by P Limited instead of 49%. Then
holding company.
This is the holding company. This is holding company of I Limited company, not R Limited company.
Correct.
So never try to understand by reading this language. He is talking about reporting company, holding company. No, he is not talking about
the body corporate shareholder.
Body corporates holding company he is talking about. When
correct.
When that body corporate, that is I Limited, is having any holding company, in that SBO you could find, then that fellow is SBO. If you could not find and another company is again holding more than 51%, then you reach to that company.
Yes.
Now you ask next question.
No, I understood now. What you are saying is, if that the body corporate's ultimate holding company, we need to find out. The shareholder who is a body corporate.
Investee body corporate.
No, that's what. That's what I'm talking about. The shareholder who is a body corporate. For that body corporate, we need to find an ultimate holding company.
Holding company.
The ultimate holding company.
The ultimate beneficial owner.
Yeah, in that ultimate holding company, if anybody individual holds more than majority stake, that means more than 50%, 50% or more than 50%, then that person will become an SBO.
Perfect.
So this is fine. In other case, in that body corporate who is a shareholder,
you tell like through this example only. Don't go to another.
Yeah, I'm telling you. In that body corporate, one person you are saying that one company is holding 51%. Another 2 shareholders, because 51% held by one shareholder, and another 2 around 25% held by one shareholder, one company. Another 25% held by 24% held by another shareholder, another companies. So in other companies, because that also we need to see, because you are saying 10%.
No, you will not see. That is why I am telling. You will not see that because once you find in the body corporate, investee body corporate, holding some holding company, others you will not see unless there is a partnership firm.
Yes, done.
Partnership firm is there, then that will come.
Yes, done.
So don't gel and mix the individual criteria checkpoints for the other criteria checkpoints.
Yeah, you mean to say that? Now I'll clarify it to you. I'll explain. If if a body corporate is a shareholder, and we need to find only who is the ultimate holding company only. And ultimate holding company, if any majority share individual shareholder is, that person only will become the SBO.
Correct.
In more than the other shareholders, maybe they'll be having more 10% or more also. We need not consider that case.
In the body corporate,
Yes.
somebody is holding 10% or not. When that company becomes reporting company, then you will check.
Yes,
Not
you're right.
otherwise.
I understood.
That company also
Yeah.
should become reporting company. That should be an Indian company. Then only the question will come for that reporting company, not for this reporting company.
Correct.
Point one.
The latest down what you told, what we discussed, that is the correct point, which I wanted to clarify.
This
It's
was
been
only the
clarified.
point.
No, I know the answer, but I wanted to clarify in a better way. That's it.
No problem. Okay.
Okay.
Sandeep,
Thanks.
go ahead.
Sir,
Nice.
one question, sir. It's Pavani here.
Yeah, Pavani, please tell me.
Sir, Indian reporting company, it's a wholly owned subsidiary of foreign company.
Okay.
And that foreign company has only two individuals who are
Okay.
husband and wife.
Okay.
So who are holding 50-50 shares.
Okay.
So then who will be the SBO? Sir? SBO concept will come or not, sir, in this case?
I will tell you.
Will not come.
For this, there is a tricky point because the concept of acting together will come or not for husband and wife is a big question. Even courts cannot decide on that, whether husband and wife will be together. But I will tell you one checkpoint, one criteria what we started doing is, in case of this husband and wife shares, husband is nominee for wife shares, wife is nominee for husband shares, then I will treat them both are acting together and I will say both are SBOs.
Both are SBO.
Because the test is that, this shares, when the wife is deceases, then X will get the shares. If X husband deceases, husband gets the shares. When husband deceases, wife will get the shares. That means they are together.
But in foreign company, how do we check that, sir?
There is no need to check. No, just ask them Ben one to give Ben one. You have to presume that they are acting together. And one more thing, if they are the same family members, and in the past, if you think, in every kind of they are same directors and all, in every kind of policy decisions, they are acting together. They never opposed or dissented for others' views. It means what?
Okay.
It means what? They are together.
You are saying that we need to see the indications.
Indications. See, indicators you have to find. You cannot, because the responsibility lies on Indian company's compliance officer. You have to presume certain things based on certain facts.
If suppose they're not husband and wife and 50-50% shares,
then there is no SBO. There is no SBO. Only thing you need to check is anybody is having a significant influence on policy decisions
so how that
financial decisions.
So how can we test check that, sir?
How
Is
can
there
you
any
check? How can you check? Only
that
one
question,
way. Only one. That person is there anyway.
Question is there.
Okay. Thank you, sir. Thank you.
Okay.
So answer to Pavani is there is no SBO, right? If it is sold, if it is sold more than 50%, then only, and you need to check
Not
the
husband and
significance
wife.
indicator. Yeah.
Not husband and wife.
Yeah. Fourth question, sir. I think you have answered this directly and indirectly. Should direct and indirect holding always aggregated even when the individuals does not hold majority stake in the intermediate entity?
Yeah. I will show one example to you, then you will understand, people will understand easily. Because I made certain examples also here. If you see, the slide is you can able to see the...
Yeah, we can see, sir.
See, in this example, X is a fellow who is having 51% in A Limited. RC is a reporting company. B Limited is a reporting company. And A Limited holds 8%. It is not holding 10%. But X directly holds 2%. So direct and indirect holding together more than 10%, then this fellow will become SBO.
Okay.
Okay.
So the answer is you have to take both, directly,
You
indirectly.
have to both for one single individual. Why it should be taken like that? I will show this example. This slide. 2(1)(h) section rule says
Rule.
any individual or group of persons acting alone or together, indirectly with direct holding, holds more than 10% or control or significant influence, then this SBO concept will trigger. That's why you have to take both direct holding and indirect holding.
Indirect holding.
And then you have to say this fellow is an SBO.
Okay. We'll move ahead, sir. Question number 5.
Yeah, I will stop this sharing.
Yeah. So the question number 5 is with respect to when there is a particular share, and that for that share it's divided into two. Voting rights and dividend rights are divided into two different individuals. In that case, do you treat both
Yes,
as
both
an
will
SBO?
become SBOs. Both will become.
Some queries there in chat box, Sandeep.
Chandrakala. Shall I read?
Yeah.
If X Limited holds 5% stake in the reporting company and Mr. A owns 50% stake in the reporting company directly and holding 95% in X Limited. In such case, whether A is identified as a beneficial owner of the reporting company. That's what we have discussed, right? Directly.
No. What our question is a little tricky. See, Chandrakala, if X Limited holds 5%, it is only for individual. You have to see direct and indirect holding, not for the body corporate. Okay, not for the body corporate. So please don't stretch beyond that. If instead of this, what he says, holding 95%, A himself owns 5% there and holds 50% in the 95% holding of X Limited, then it will come. If in your question, instead of X Limited, A is mentioned there, then it will applicable. But for X Limited, is not, because once you find in the reporting company somebody holds less than 10%, then you will not check who is that fellow behind that fellow at all. Not required at all. Understood? In your reporting company, if some another company holding less than 10%, that is 5% X Limited, you will not bother who is behind X Limited at all.
Chandrakala, you want to come in? You got the answer?
Maybe she will
hello, sir.
Sir, question.
She's there.
Hello, sir. Is it audible?
Yeah. Audible, very much.
Good evening, sir. So my question is, in this case, in X Limited, Mr. A directly owns 50%.
Okay.
In a reporting company, A directly owns 50%. And one body corporate is also there. That is also Indian company, private limited company. In our reporting company, that private limited company is holding only 5%, not 10. It is not triggering directly 10.
That's what I'm telling, Chandrakala. Once in the reporting company, another company holds less than 10%, being a body corporate, you will not think of that fellow at all, that company at all.
No, but sir, you just now you told that aggregation.
Indirectly,
I will tell you, please, Sandeep, please understand.
Yeah.
Instead of body corporate, if some same A fellow is holding, then it is a different story. So that in the 2(1)(h) definition rule, what it says is, if an individual holding together or with group of persons, then aggregation should happen. It is not for a company.
So in this case, individual is holding directly, and
individual holding directly in the reporting company, so there is no SBO story there.
And at the same time, the same person is holding indirectly through X, where it is only 5%.
5%.
So 5 plus 50%.
You will not aggregate. You need not aggregate. You will not aggregate at all. Because it is no need to go beyond that company at all. Go after that company at all.
Can you share that aggregation wala just now you shared, na?
Slide, sir.
I will share it.
Can you correlate with that slide?
I will tell. if in this X company, if in this B
Take the
limited,
same example of Chandrakala.
Chandrakala,
Sir.
Chandrakala, instead of this is 10%, actually there is another one which is 5%, I think.
I think in this case, only you take individual if he's holding less than 10%. Since
Correct.
here is already holding more than 10%, that is 50% here. So no need of discovering
No need of
SBO
checking.
and all.
No, not because of that, Ramki. Your answer is right, but logic is because your investee shareholder, that is a shareholder body corporate, is holding less than 10%, you need not check for that company at all.
So you think then if the ex-limited is holding, let us say 10% in the same case.
Exactly. If I will say
If
here,
ex-limited is,
I will just change the numbers here. Just please be here.
same, you take same example, Ramna.
And the same example only. Same example only.
He's editing.
Same example only. We will just read this thing. Explain this case. A limited holds 8% only.
A limited holds, so how much?
In B,
5%. Chandrakala's case is 5%.
Chandrakala cases 5%.
Okay.
Behind this is XA is there. Yeah, that A only, no? That fellow.
Yes.
A is there. Okay. And the same fellow directly also hold more than 51%, you are saying?
So A in reporting company holding directly 50 plus, sir. And this A is having 95% stake in X Limited. That X Limited again invested holding 5% stake in reporting company.
Ramna, simply answer to her.
1 minute, we will close this, then I will
Ramna, simply in the example given by Chandrakala, if X Limited holds, let us say 10%, and remaining figures are same. So in such case, Mr. A becomes SBO.
Correct, sir.
Yes. Chandrakala has the answer to you.
The first criteria, when first criteria is meeting, then we will dig out who is the beneficial owner. In our case, first criteria, in first criteria, body corporate means X Limited is holding only 5.
Yeah.
It is not at all meeting 10%.
I think Ramana already told, identify SBO. First you see who are the shareholders of reporting company. If individuals are there, take out. If there is body corporate, and if that body corporate must hold 10% above, then only question of SBO will come. As answer, in fact, answer lies there only.
Answer lies only one exception here in that. If in this example, what you said, Chandrakala, if X Limited holds 5% stake in reporting company,
sir,
and A owns 50% stake, if he holds more than 51% stake, more than 51% stake, not 50, more than 50, not 50, then the answer will be different. Okay?
For example, if A owns 50 plus, sir, in the reporting company,
he will become.
Because
now individuals say you are telling direct, indirect, having control. Okay?
So in this case, if A owns 50 plus stake in the reporting company, then indirectly holding is to be added.
Indirect to be added there.
If it is 50, we should not add.
We will not add because it is only 5%. No, why you will add it?
No, sir. A bit of confusion. So if A owns in the reporting company 51%. Let us take A owns in the reporting company 51%.
A is an individual.
A is an individual who owns 51% in the reporting company, and some X Limited, which is holding 5% in the reporting company. And in that X Limited, this A, Mr. A itself is having the stake of 95%, A himself. Means indirectly that X Limited majority stake held by this A only. But X Limited is a holding is not having any holding subsidiary relationship with our reporting company because it is having only 5%.
Correct.
So in that case, as you said initially, if starting point 10% triggering point is to be taken, or indirectly stakes are to be added for identifying him as a beneficial owner.
The question for you is, if it is an individual holding indirectly and together with direct holding.
Yes, sir.
Okay. SBO will come. But in the initial stage, what will happen? Once your shareholder itself is a below 10%, then that question will not will not arise.
Indirectly, what is the impact of word indirectly in this case?
Indirectly,
Ramana,
Through a company.
Ramana, the difficulty arises here is unless X Limited holds 10% above, generally you don't look into it.
yes.
And in X Limited, let us say A is holding 95%, and A is directly holding in the reporting company, let us say 50 or whatever is the percentage. You will not get an apprehension that whether A is connected to this X Limited or not, because you simply discard X Limited because X Limited is holding less than 10%.
Correct.
Difficulty arises unless you know that the so-called A is holding more than 50% in X Limited, then only that the question of SBO discovery and all will arise.
Correct, Ramki. But once you know in the X Limited, there is somebody is holding directly control.
No, same. You take it the
Same example. Same example. If 95% stake is already held by A.
No, Kadramana, rule A is that if X Limited is holding in reporting company 10% above, generally our attention goes there. Then I'll try and see who is there behind X, blah 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 blah.
Yes.
And if X Limited is holding less than 10%, you can't simply exclude that X Limited. Simply exclude that X Limited. Don't try to see who is behind this and blah blah blah. Because even though X Limited is holding less than 10%, if this kind of structure is there behind this, then SBO also would exist there.
I will tell you. Your point is right. Here, only thing what you need to do, extend your stretch. That is where you will get, you are a compliance officer where you get a doubt, you have to travel beyond. Okay. So normal process, we will definitely exclude less than 10% fellow, we will not see. But in the same company, if somebody is having control of 95% stake directly, whether he will become SBO or not, what way you bother? Understood? He is already having 95% control in the company.
No.
So you need not worry. See, in this case...
You don't know whether Mr. X is holding how much percentage in X Limited. Unless you dig into X Limited shareholding,
Indirectly.
you will not know. So the question here is that, like simple example which was shown initially, take a list of shareholders, exclude all individuals, and then you go to body corporate. If the body corporates are holding 10% above, then try and see whether SBO attracts or not. And after that, if any body corporate is holding less than 10%, don't exclude those body corporates. Don't exclude those.
Don't exclude those body.
No.
I will tell you.
Individual is holding more than
don't exclude
than body corporate, and if that individual is holding any direct investment in reporting company, then I think you have to act for.
I will, Sandeep.
Sir.
To put
hold directly, indirectly, 10%.
Hold directly, indirectly. See, this thing is, what Ramki said is right. You will not directly exclude it. But when you are checking your shareholders, reporting company shareholders, if you are having a direct control over the reporting company, then it doesn't matter whether you are SBO or not. Understood?
So in that case,
hey, Baba, you are only directly controlling the company. What way you will, become SBO or not for this company? What way it matters to me as a ministry?
Okay, if I change the question, if he directly holds 5% and indirectly through X Limited company holds 5%, then it will come.
Yes, come.
So you are saying that if he holds more than 50%, then
because in her question she already told more than 51% is already 50 or whatever.
If it is 49%?
49%, then you should not take, because it is only 5% control is taken.
Okay. Because I believe that, sir,
is it you are agreeing to it or not?
I need to add 50% plus 5% indirect holding.
No,
sir,
what I mean to say is, tell me.
That this 50% condition is to be checked in case of indirect holding, no.
Yes, correct. Not for direct
Indirect holding case only, this 50%
Yes.
criteria is to be checked.
Only for SBO, only for understanding the control point, then only you will check. Otherwise,
But
you will not
we
check
need
at all.
not see the holding in the reporting company by the individuals. Per se, sir, in this reporting company, if all individuals only the shareholders, then in such case, no question of identifying the beneficial.
Chandrakala, just see this definition. Holds directly or together. Can you see this rule?
Yes, sir.
Holds directly or together with any direct holding. Holds indirectly or together with any direct holding. In your case,
that is what my point, sir. Indirectly, how it is to be emphasized? Do we add both percentages?
Indirectly,
you should add it.
Okay. In such case, 49%. In such case, 49% or 50, 51% is is having any relevance in it.
No.
As long as it's exceeding 10%.
Correct.
So even in this case, X Limited is holding 5% and A owns directly 10%. In such case, also having 10 plus 5, 15. In such case, also Mr. A has to be identified as a beneficial owner. No need of having 50 plus.
No. See, why I am telling 50%, your case, you see. In X Limited, 95% is held by A.
Yes, sir.
Okay. So, in the X Limited, when it becomes reporting company, there is no discussion directly. There is no SBO at all there for that company. But for this company, reporting company, R company, you give name of the R company, then it is clear. What you said is right.
So it attracts beneficial ownership.
It attracts and you should add it.
Okay. Fine.
I'll move on to the next. I'll move on to the next question.
Thank you so much.
Yeah.
This is with respect to preference shares, sir. So preference shares generally when the company don't pay dividend for next 2 years, then they attract voting rights, right? So in this case, the preference shareholder who has a voting power will fall under the SBO.
Here I will explain in two different perceptions. One is if the preference shares are convertible preference shares, like CCPS. In the definition of shares, in relation to these rules, it is already included that the convertible CCDs or convertible shares and GDRs are part of GDR or ADR. I think GDR. GDR is already treated as shares only. So direct beneficial ownership story will come there. But in case of preference shares which are non-convertible, again, two questions will come. Whether this non-convertible preference shares is having a dividend on
cumulative or non-cumulative?
Non-cumulative. If it is a cumulative basis, then only they will normally accrue the rights for 2 years. If you have not paid the dividend, then they will accrue the right of equity shareholders. Otherwise not. So in case of cumulative preference shares, non-convertible preference shares, if the company fails to make the payment for 2 consecutive years and then they invoke that provision and try to exercise the rights, of course SBO will come.
So the answer is yes. In case if it's a cumulative preference shares and voting rights occurs, then they will fall under the definition of SBO.
For non-convertible. Convertible anyway, they are part of the SBO only.
Right. We'll move on to the next question, sir. I think you have already answered this. Should all partners automatically be treated as SBO in case of a partnership firm or a LLP who's holding shares in the company?
Yes. Every partner, even 1% share also.
LLP, partnership firm, both.
Yes.
So if there are 20 partners, all has to file SBO?
Everybody. That's like, in Pushpa movie, they say no 5% partner. Even that fellow will become.
Okay. Sure. We'll move on to the next one, sir. Karta. Under SBO rules, Karta is treated as SBO when HUF holds shares. If HUF holds shares but individual members also hold shares directly in the company, how should direct and indirect holding be aggregated for SBO determination?
Yes, it is. He is an individual only. Obviously, he should add directly, indirectly. I will try to place one example here. Wait, 1 minute.
Yes.
This is a Hindu undivided family where Karta you will see. Here in the
Sir,
example.
you have to 1 minute. I have to stop sharing.
Okay.
Share it once again. Okay?
Oh, it's not appearing?
Not appearing.
Okay. This is a...
It was appearing actually.
Oh, is it?
It was appearing for us.
Yeah. In this example, X is a Karta. HUF holds 8% in A Limited, RC company, and
Mhm.
X directly holds 5% in A Limited.
Okay.
Then he will become SBO.
13%.
13%. But I will change another example here.
Sir, in this only, I have one question. Suppose not Karta.
That's what.
Any,
Okay.
any other member of HUF?
That's what I am showing you.
Okay.
Here, this is an extended level of example. Karta is holds 10% directly, and HUF may minor member holds, and Karta is a guardian of this minor. Then also he will become. But if this fellow is a major,
And it's a part of HUF.
And part of HUF, and Karta doesn't have anything, he holds only directly, then there is no SBO.
Then that PAC will not come, sir?
Not come. Why? Because the individual who is holding is less than 8%, and it is not HUF is holding, he is holding in his individual capacity. This fellow Karta is also holding in his individual capacity. That too direct holding.
Right. Okay. So
Anybody has doubt? Chandrakala?
Then the next level of I think that person acting in concern. Do we need to identify that indicator or something like that?
Which one? Person acting in concert.
Concern.
But doesn't matter. Person acting in consent only comes when it is indirect holding.
Indirect holding.
When both fellows hold directly, then where is the question of acting together?
Right.
It doesn't matter whether they act together or differently.
Suppose, sir, in this, can you share once again?
Yeah.
If Karta holds 5%.
Before one, huh?
This one. If the Karta holds 5%, and if this guy holds 5%, directly, then it will not come. Yeah, it will not come. Yes.
It will not come. So, Karta, whether he is holding on behalf of HUF or not, is the first question. Whether
that is only an indirect holding.
For indirect holding. If Karta is holding directly in his personal capacity, or member of the HUF is directly holding in his personal capacity,
then you aggregate it.
That is direct holding itself. SBO concept will not come at all.
Okay.
I am holding my behalf, boss. So I am not holding anybody's behalf.
But the earlier that aggregation will not come, sir. He is holding indirectly through the HUF and directly through by his own.
That's what I'm telling. HUF if HUF is holding, then it will come. If he is holding in his individual capacity, so I am like Karta of my HUF. But I have nothing to do with HUF when I hold some shares in Reliance.
Right.
So you have to go beyond that to find whether HUF is a shareholder or Karta is a shareholder, enter in the register of members.
Okay. We'll move on to the next question, sir. I think this is very important. This is where, because initially whatever the stages are, they're all black and white, 10% or majority and all. The next question is about significant influence versus control. So, there is a definition of significant influence under the Companies Act, and again there is a definition of significant influence under the rules as well. Both place different. One under Companies Act, it says 20% of the voting power, whereas in the rule says participation in the policy decision under SBO rules. So, what do you take as a significant influence?
I have placed it on the screen. The significant influence always has a concept only in the SBO in relation to SBO provision only, not for any other purpose. So whatever definition is given in section 2 should not be considered here for finding out significant influence when you are trying to ascertain the implication of or application of section 90. So it is an independent definition, independent explanation. You have to follow this separately. And this significant influence, again, directly, indirectly, two things it is pushing. One is first financial and operating policy decisions. So here we need to understand what is the financial or operating policy decisions. Policy is normally taken by either a body like board or even sometimes an individual by virtue of an agreement or otherwise he will have the policy decision. So what is policy decision? What is financial decision? If you are trying to buy an asset of 10 crores, it is a financial decision. A policy decision to give ESOPs to all the employees who has completed 5 years is a policy decision. So when you are influencing that policy decision, power to handle that policy decision in financial decision, then you are an SBO having significant influence. But if decision is taken and somebody is ESOPs MD is appointed to handle the whole project for the 10 crore project, then he is only having control over implementation of that policy decision or financial decision.
That's not an
He
influence.
is not taking the decision. He is only implementing the decision. Then he
On the
will not
capacity
become
of
he will not become SBO. So the first question is whether this fellow is having control over financial decision or control over policy decision. Then only.
Okay. Sir, but what you said is with respect to if there is an agreement between the company or the person, right? How will you identify when there is no agreement?
That's what even this issue was there when many earlier corporate scams happened. The person who is behind is once in one session of the or some ROC official or MCA official, he was one session was there on investigations in the ICSI Institute chapter. So he was telling they will go beyond to some extent that the bigger size checks or bigger size payments are signed by whom, or even check is not signed, but approval of somebody is taken through mail, whether I can release the payment. To that extent, they go and check whether they are having. But here, you need not worry so much because it is only policy or financial decisions. There will not be hundreds of policies, hundreds of financial decisions in one particular year in a company. There will be very few. Transactions may be hundreds. Financial transactions may be hundreds. But decisions will be very few.
Right.
So it's not much a big, Hercules task, but of course it is a challenge.
We can move ahead, sir.
Yeah.
This is with respect to person acting in together. You already explained this one in case of a husband-wife. Can you give some more examples where we can indicate that these persons are acting in concern? Because in one of my I have one example, sir. It's not husband and wife, but there are promoter group. So they were holding indirectly through a promoter group, but everybody was holding 20%. Like, suppose say 5%, 5 promoters are there. Everybody was holding 20%. So nobody is holding majority stake. In this case, how will you identify that these are promoters are acting together?
So
persons acting together.
Yeah. What you need to find out is the another checkpoint. What you should check is whether these group of promoters are individuals. Is there any pre-existing shareholder or share purchase investment agreements, either here or in any other company by the same group is having multiple group companies they are holding, and in those group companies there are any agreements, contracts or agreements are there. where it is indicated that these people are together going forward. Or LLP is there, some partnership firm is there where these fellows are again doing the another kind of business. So it indicates that not exactly, but there is a point to raise a iota of doubt, mentioning that there is some fishy thing where these people have some common intent, common interest.
But generally, what happens, this will be through an indirect holding. So their agreements might be confidential, which we don't know as a reporting company.
No, the
So-
best thing is not what we do regularly is first we will ask for Ben 4.
Okay.
Ben 4 undoubtedly without any issue and concern. It comes directly.
So Ben 4 is that you are asking to a person that we believe that you are persons acting together. So what is your
No. Ben 4, you don't go to Ben 4 level in the initial stages. Nobody can go. Even we have a delicacy situation. Many employed company secretaries are there in this session also. It is very difficult for them directly to go for Ben 4. First of all,
going to the promoter?
they will get a pink card first if they are going beyond that. So practical thing also we will take it. So what we can do better way, first to take Ben 1. Ben 1 is clear.
Take Ben 1 means you will ask for Ben 1.
Ask for Ben 1. Take Ben 1 you will ask. If they say that there is nobody in confirmation, you take the written confirmation from them in a declaration format. If they are not giving neither declaration format nor Ben 1, they are saying no. Then there may be, you have to create an evidence or situation where you have reasons to doubt, get a doubt that you have to go for the Ben 4. Then you will have a saving both ends, either from the reporting authority of your company or from the investor side also or from the regulator side also. See, I have made my efforts. Ben 1 I have asked for, I have asked for the declaration. I have traveled beyond the certain time where now there is a doubt. So whoever is employed CS, rely always on the documentation, putting things on black and white, without hurting or without showing your aggression, but very delicately, very diplomatically put the things on paper. Then you will be a safe player.
What you are trying to say is you place it before the board that there is a section where it says that you need to identify the person acting together. So from the board.
Not initially.
Because company secretary can't do that.
No. First initially ask for Ben 1. They won't give Ben 1. Ask for declaration, they won't give. Then place it to the board. This is asked for. Strategically you should move. And see, one I always believe that thanks to again R&A where I got right. First thing we should learn is how to say no. We should know how to say no first. And we should able to put always our things very politely, humbly, but firmly. So that thing we have to learn. You should be very firm, but be polite and humble. No problem.
Most of the company secretaries in employment might not, because this is a tricky situation, right? Because I'll give you one situation wherein we thought that just now I told you 20%. We went to them and they were like, I don't know, you figure it out, you tell me whether we are persons acting together or not. Then I don't have an indication, because he was like, if you feel that we are persons acting together, you can file it.
No,
So what is the definition?
Hell is not going to fall if you are telling somebody is SBO. Hell is not going to fall.
But because it says common intent, what is the definition of common intent? Whether economic interest is a common intent, because every promoter or every director or every shareholder will be investing in the company as an economic interest only. So that is, can you say that is a common intent?
See, I will explain you. Common intent is different from common interest. Common intent is on any decision, my and your intent is same. Of course, intent will be the source for interest, or interest cannot be inseparable with intent. But it is need not be always be together. There may be common interest because you are holding shares in Reliance, you are having interest, and I am holding shares in Reliance. I am holding common interest. We both have having interest
Common
in
interest.
shares, common interest. Because if Reliance something happens to Reliance, you get affected, I get affected. But we need not have common intent.
Interest.
Yeah,
Common.
interest. But you may have common intent there. When we are on the board of the some company XYZ, we may have our intentions very clear, common.
Right.
In expressing our views, in putting our voting, exercising our votes, there may be the common intent. So the section is all about common intent, not about interest.
Okay.
If you say common interest, then everybody is a SBO. Because everybody is interested in their own investment, their own this thing, money.
Right.
Okay.
So as you said earlier that indications you gave, so that need to be taken care.
Yes, yes.
Sir, one thing I missed it with respect to significant influence. How can you establish? Because if a person does not have any shareholding nor a directorship, can you give any examples where
Examples I will
practical examples in Indian companies? Examples where Indian companies where you can see that these are significant influence. Any big company's name you can you give?
Big company name we need not take, but we can say some of the examples.
Just to understand what can be a situation where there is a significant influence.
Significant influence is where we file commonly the either non-executive or executive directors, executive or non-executive directors, all are reporting to same chairman.
Okay.
Ultimately, nothing will happen unless the chairman says yes, nothing will move in any of the companies. So better always try to travel beyond maybe AS 18 disclosures, maybe MBP once, give some clue that whether somebody holds significant influence or not. If it is the unwritten thing, if it is a written agreements and all are there, then it is very easy for you. Check like investment agreement, shareholder agreement, all these stories.
No, the question is that only the person does not hold any shares or directorship, then there is no agreement. Then it is purely on the.
If you ask me, and what I do in my, in the place of that, then what I normally do is when one is the first thing I will try to strategize. Okay. If it is working, then I'm happy. I'm closing all my this thing and happily go and sleep. Right. If then one is not coming, my doubt travel beyond. Then starts thinking.
Right.
Doing some investigation, understanding whether these directors in this company, who is the majority shareholders.
Sir, who should do this? Who should do this exercise? As a company secretary, or as a company secretary, you give it to the board that this is the thing you
company
just figure it out.
Secretary only. Board you give, board cannot give. You cannot give any homework to board. You only has to do go background checks, check for common shareholding of these fellows, check for common directorships of these fellows, check for the any directors reports or that chairman reports. Group companies, it is easy to find. If it is not even group companies, then where you will go, where all you will do exercise. Especially secretarial auditor, when when I don't know how many secretarial auditors go beyond to find the SBO forms are filed properly or not, or company secretary has done this exercise properly or not. It is really, it will take 1 to 3 days time to find out this story. So it is all up to you whether you will have your own judgments and rely on some information. But my suggestion as a senior member or as a institute perspective also, what I say, better to follow the guidance note on secretarial audit. Make your paper properly ready and try your disclaimers written properly, and your reliance on information indicate properly in your report. Have the backup document. Then you will be 95% safe. 5% any inherent risk in our profession, or nobody can exclude or eliminate.
Okay, sir. I think we have covered most of the questions. I'll take one last question and we can go for Q&A. Because even Q&A was during the session only, there was a Q&A. When the last question, sir, where the shares are held through a employee welfare trust established for ESOP, should the trustee or the employees be considered as SBO?
I will tell here one thing, whether the trust is holding excess at the options stage only, or they have exercised and got the shares with them, is the first question. If it is in option stage only, then there is no question of thinking of SBO or any other sort of thing. Second thing is, if their shares are exercised and shares are already there, everything is on paper and beneficial owners are these fellows, and that trust is a specific trust. End of the day, because it denotes who owns what. When in specific trust, the criteria checkpoint is the beneficiary is the SBO.
Right.
So if somebody...
Beneficiary or trustee, sir?
No, specific trust.
Specific trust.
Trustee.
So this ESOP trust, employee trust, is what kind of trust it will be?
It will be specific trust, because how many or what share the beneficiary will own, it is clearly mentioned, no?
Right.
In the same employee trust, XYZ are employees. X get how many shares, Y get how many shares, it is clearly mentioned. No, it is a specific trust, obviously.
Right.
There is no any second case of trust will be there.
So specific trust beneficiary will come.
Beneficiary will come.
But beneficiary generally will not hold that much of percentage in case of ESOP. The percentage will be nominal.
So
yeah.
I have never come across any kind of this kind of case. Maybe it's a more hypothetical case, but because see, one basic fundamental thing you should understand: what is the total pool of ESOPs that can be granted by a company out of entire shareholding of the company? It is only some percentage in the ESOP rules. 5% or 10%. 10%.
Right.
So the entire pool of ESOPs itself is 10%.
Technically, it will not come.
There is the question of somebody becoming SBO there.
So in case if there is only one employee,
no company can issue 40% of its entire capital as a ESOPs. No.
Right.
So there is no point. There is no case will come. As per my understanding, it is practically impossible to have that kind of situation.
Okay, sir. Then I think most of the questions has been covered. I invite if anybody has a question and answers question, we can address that.
Yeah, well, one thing is good that Sandeep, when they joined in the session 44 were there, till now nobody has left.
Right. No, it was 65. Slowly, but it's a good number. It's a good number. Ramakrishna, sir.
Ramakrishna,
any concluding remarks from your end?
Sir,
most of the questions have been covered.
Yeah. Significant beneficial owners. I think that's nicely Ramana has covered the subject. I mean, I think, at one go, at one reading,
Hmm.
you will not get the comprehensive understanding of what SBO and when there is SBO, how to identify SBO and all. With more and more practical questions, practical scenarios, you can understand the SBO concept very good. I think Ramana has done fairly has done his job in making all of us to understand the SBO concept. So I think it's good. In case still any questions are there, you can ask the participant to maybe write to us, and then we can examine them with the help of Ramana and then answer them.
Yeah. Anyway, our group is there. In that, anybody can pose any questions.
Alumni network also people can post.
Even after sessions, also in practical life, if you get any issues or concerns, you can always post it. That is a big, satisfaction and confidence for us that we have 50, 60 people who are with us to support and guide us.
Right, sir. So thank you very much, sir. So it was an insightful session, and I think most of the people and most of the questions have been covered, and this session was truly insightful. So with this, I will conclude, sir. Thank you very much for giving us an opportunity of being an expert here and and giving this so insightful this.
Thank you very much, Sandeep, for wonderful opportunity, and Madam and Ramki, all partners governing for. First of all, this is a very good initiative that you have taken. Where the people would be allowed to join, keeping aside all their engagements to learn the subject.
Sure.
Right.
Good.
Okay, sir. Then.
Thank you.
Thank you.
Bye.
Thank you.
Bye. Bye.